Hello, guys. So let's begin. I need to start from trial of an offense today. Trial is judicial adjudication of a person's guilt or innocence. Trial means जो कोर्ट्स में केसेस शुरू होते हैं और एक पर्सन को मतलब इल्ज़ाम लगा होता है. देयर इज़ अ क्लेम on one person that whether he has committed the crime or not, right? So we blame or we claim on a particular person that this person has committed the crime. Now in a court it is proved that whether or not he has actually committed that crime, right? So that happens in a trial. Trial means the proceedings that happen in a court. Under CRPC, criminal trials have been categorized into three divisions, each having distinct procedures called warrant, summons, and summary trials. So under CRPC, as we have done that, CRPC tells what the procedure would be to handle a suit or to handle a case. So as per CRPC, criminal trials are categorized into three parts which have different procedures: warrant, summons, and summary trials. I told you what a warrant is: search warrant or arrest warrant, that all. Summon is to call somebody. A warrant case relates to offences punishable with death or imprisonment for a term greater than 2 years. So if there is a case or a crime which has been committed whose punishment is death or imprisonment for a term greater than 2 years, then warrants are issued for arresting that person or to search in the house of that person. Different types of warrants are produced. CRPC provides for two types of procedures for trial of warrant cases by a magistrate. Now there are two types of procedures in which warrant can be tried, and the proceedings can initiate in lieu of a warrant which has been issued by a magistrate. Those instituted upon a police report, those instituted upon complaint. Means if there is an FIR registered with the police, that is a police report. If it is, then the procedures can be done, and if the complaint is directly with the magistrate, then too the warrant cases can start. In respect of cases instituted on police report, magistrate may discharge the accused upon consideration of police report and documents sent with it. Magistrate need not hear the prosecution or record further evidence. So if there is a police report and on the basis of that police report the case goes on to the magistrate's court, then magistrate can directly, without further investigating into the matter, of without further checking all the merits or circumstances or facts and situations of the case, he can directly discharge the person. Means he can directly say that okay, you have committed this crime, or okay, you haven't committed that crime, just on the basis of the police report, because it is understood that if the police had registered an FIR, then they may have taken some investigation also into consideration. They may had seen the merits or the situations of the case, and they may have done some of the other investigation, and that investigation record or documents are also sent along with the registered FIR to the magistrate's office. In respect of cases instituted otherwise, means it's directly come to the magistrate or somehow other way than the police report, magistrate is bound to hear the prosecution and record evidence. If there is no case made out, accused is discharged. So if the case has come other than on the basis of police report, then magistrate is bound to hear the prosecution. Means the victim's part को prosecution hear करता है ना, तो he is bound to hear, he is bound to record all the documents or evidence, to collect evidence of that. He may or may not discharge the accused. In both cases, if accused is not discharged, magistrate holds a regular trial after framing the charge. Means if accused is not set free, then magistrate will hold a trial. Now there will be a proceeding set upon for क्योंकि अब प्रूफ हो गया कि अक्यूज ने एक क्राइम किया है, तो हम उसको छोड़ेंगे तो है नहीं. मतलब जिस पर्सन पर ब्लेम लगा था उसने एक क्राइम किया, तो हम उसको छोड़ेंगे तो नहीं, तो हम उस पर चार्जेस लगाएंगे एज़ पर द IPC सेक्शंस. उस पर चार्जेस लगेंगे and then there will be regular trial proceedings or the court proceedings. जैसे होती हैं वैसे होंगी. In respect of offences punishable with death, life imprisonment or imprisonment for term exceeding 7 years, trial is conducted in a sessions court after being committed or forwarded to the court by a magistrate. So if there is a crime which has the punishment of death, life imprisonment or imprisonment of more than 7 years, then the trial has to be conducted in a sessions court after the report being sent by the magistrate to that court. A summons case means a case relating to an offense that is not a warrant case. So summon case is warrant case, you understood, wherein the calls have been made or by the police or by the magistrate report. The cases are dealt with in different ways. Now summon case is a case relating to an offense that is not a warrant case, that is cases relating to offenses punishable with imprisonment of less than 2 years. As we just read, warrant case was associated with crimes which have punishment of imprisonment of more than 2 years. Let it be death or life imprisonment or any such thing, but more than 2 years that has to be. So summon case is relating to offences which have punishment of imprisonment less than 2 years. In respect of these, there is no need to frame a charge. Now in the former one, the magistrate frames the charges, charge sheet is prepared, and then that case is taken into a session court for regular proceedings. But in summon case, there is no need to frame a charge or charge sheet as such. Court gives substance of accusation, which is called notice, to accused when person appears before the court. Summon means to call upon, to order or to call upon. So the court gives the summon that or a notice that you have to appear before the court at this date at this time. Court has power to convert a summons case into a warrant case if magistrate thinks that it is in the interest of justice. CRPC provides that certain petty offences may be tried in a summary way. In a summary trial, no sentence of imprisonment for a term exceeding 3 months can be passed in any conviction. So CRPC says that for trivial or petty cases, बहुत small or trivial matters के लिए, छोटे मोटे झगड़े के लिए, that can be निपटा सकते हैं उसको हम summary way में. There is another way, summary way, which is for the offences that have imprisonment for a term not exceeding 3 months. Usually in such cases, special summon is sent to the offender requiring him to either attend court and defend himself or admit guilt and pay a fine by post. So in these cases, since these are trivial matters, so then do a summon or a notice of calling him for him to appear in the court at this particular date, this particular time. उसको एक मैसेज दिया जाता है, समन या ऑर्डर देते हैं, नोटिस इशू होता है कोर्ट से कि आपको एक हियरिंग होगी और उसके लिए आपको इस टाइम पर, इस डेट पर कोर्ट में प्रेजेंट होना है. Either you will defend yourself, you will say that I haven't committed the crime, or you will admit that you have committed the crime, and if you have, then you will pay the fine by post. If a fine of rupees 200 or less is imposed in such trials, accused has no right of appeal. So if fine is of rupees 200 or less than 200 rupees, then accused has no right to appeal in further higher courts of law. Common features in all three aforementioned trials may be roughly broken into following distinct stages. Framing of charge or giving of notice. This is the beginning of a trial. Okay, so you give the notice that we have a claim against you कि ये crime आपने किया है. These are the sections in IPC जिसके हिसाब से ये charge sheet बनी है. This is the beginning. At this stage, judge is required to weigh the evidence gathered by police during investigation to ascertain whether or not a prima facie case against the accused has been made out. Prima facie means on the face of itself, मतलब सीधा सीधा दिखे, सिंपली और बहुत आराम से सीधा सीधा दिखे कि हाँ इस बंदे ने ये क्राइम किया है. So in the first beginning stage, the judge or the magistrate is required to see that what all documents or evidence is gathered by the police as per the report which is registered with them, and then he takes any further step, and it then also makes out that whether it is a prima facie case or not. In case material placed before court is sufficient, court frames the charge and proceeds with trial. Now, if the documents or evidence which is gathered by the police during investigation that is sufficient as per the merit and situations of the case, then the magistrate or the court can proceed with further trial, with further proceedings of the case, or if not, then obviously they have to collect more evidence to prove. If on contrary judge considers materials insufficient, the judge discharge the accused. उसको तभी के लिए छोड़ देते हैं, जैसे कहते हैं ना बेनिफिट ऑफ डाउट मिल गया. सो बेनिफिट ऑफ डाउट से अगर सफिशिएंट एविडेंस ना हो अक्यूज्ड के खिलाफ तो उसको उस समय के लिए छोड़ा जाता है, बिकॉज देयर वर नो सफिशिएंट एविडेंस टू प्रूव थिंग्स अगेंस्ट हिम and records reasons for doing so. Charge is read over, explained to accused who may plead guilty or not guilty. So accused को ये भी बताया जाता है कि आपके अगेंस्ट कौन कौन से चार्जेस आईपीसी के किस सेक्शन के तहत लगे हैं. If accused pleads guilty means if accused accepts that he had committed the crime, judge shall record the plea and may convict him. If accused pleads not guilty and claims trial, then trial begins. If he had accepted it simply, then judge will record the जो उसका बयान होता है उसको रिकॉर्ड करते हैं कि इसने हाँ उसने मान लिया दैट ही इज़ गिल्टी, सो देन उसको पनिशमेंट दी जाती है. बट अगर वो नहीं माना तो फिर कोर्ट में केस चलता है और बहस होती है और उस पर प्रूव हुआ नहीं हुआ. दैट ऑल हैपन्स इन द कोर्ट प्रोसीडिंग्स. देन you may note that actual trial starts only after charge has been framed, and the stage preceding the trial is called inquiry. After the inquiry, charge is prepared, and after formulation of charge, a trial starts. A charge is nothing but formulation of accusation made against a person who is to face trial for a specified offense. It sets out the offense that was allegedly committed. We claim that this person has committed this or that crime. So that crime as per the sections of IPC, उसमें चार्ज शीट बनाई जाती है. इस सेक्शन के तहत इसने ये क्राइम किया, ये इस सेक्शन के तहत ये क्राइम किया है. तो दैट हैपन्स आफ्टर द इंक्वायरी. इंक्वायरी करी जाती है. कुछ जो आई विटनेसेस होते हैं या जो विटनेसेस होते हैं उनसे पूछा जाता है दैट हैव यू सीन दिस पर्सन और हैव यू सीन. सो सच टाइप्स ऑफ इंक्वायरी are made not only from the victim or from the accused, but some witnesses also which may be present at that crime scene, the place where the crime has occurred. So that all happens after inquiry. The charges are made out in the charge sheet, and then after the trial begins. Recording of prosecution evidence. After charge is framed, prosecution is asked to examine its witnesses before court. Means आपने पहले witness से पूछ लिया, but now you have to produce those witnesses in front of court also, in front of the judge also, कि उनको भी believe हो जाए that yeah, these are the evidence or these are the witnesses which you have. This is called examination in chief. The accused has a right to cross-examine all witnesses presented by the prosecution. Means जो अक्यूज्ड है जिस पर ये क्लेम लगा है कि उसने ये काम किया है, तो अक्यूज्ड को ये राइट है कि अगर कोई विटनेस उसके खिलाफ बोल रहा है तो उसको क्रॉस क्वेश्चन करने का राइट अक्यूज्ड को है. प्रोसिक्यूशन इज जो कि द लॉयर हु फाइट्स ऑन बिहाफ ऑफ द विक्टिम फ्रॉम द गवर्नमेंट लड़ती है विक्टिम के बिहाफ में. तो और जो गवर्नमेंट का लॉयर होता है इन क्रिमिनल केसेस में उसको कहते हैं पब्लिक प्रोसिक्यूटर. ये मैं बता चुकी हूँ. CRPC provides that when examination of witness has once begun, it shall be continued day to day until all witnesses in attendance have been examined. तो जब तक सारे witnesses की बयान नहीं लिए जाते, उनको रिकॉर्ड नहीं किया जाता, तब तक डे टू डे प्रोसीडिंग्स चलती हैं. सारे विटनेसेस जिनके नाम लिखे गए थे रजिस्टर में वो सब आते हैं. ऐसा नहीं होता कि आज हमारा मन किया हम इस विटनेस को प्रोड्यूस कर दें तो वो हो जाए. नो, देयर इज़ अ रजिस्टर्ड विच इज़ वेल मेंटेन्ड बिफोर द कोर्ट प्रोसीडिंग्स टू स्टार्ट कि ये विटनेस मेरे पास से हैं, एंड दैट ऑल विटनेस हैव टू अपीयर डे टू डे. They have to give their mandatory attendance, and once they all are examined और उन सब का बयान ले लिया जाता है, तब जाके विटनेस का जो एक क्रॉस एग्जामिनेशन या एग्जामिनेशन चीफ प्रोसेस होता है, दैट ऑल एंड्स. statement of accused, court has powers to examine accused at any stage of inquiry or trial for purpose of eliciting any explanation against incriminating circumstances appearing before it. So at any particular point of time, court can start the inquiry or trial of the accused. उसको लगा कि आज हमें एक नया document मिला है इसके against, so they can start the proceedings. However, it is mandatory for the court to question accused after examining evidence of prosecution if it incriminates the accused. So as everybody has a right to defend himself, so as it happens in the court has the right, and it is mandatory. It's not the right, or it is duty of the court to question the accused that why, after seeing all the evidence in record, all the documents related to the case, it is the duty of the court to ask the accused that why you have committed, or are you admitting it now. This examination is without oath and before accused enters a defense. Purpose of this examination is to give accused a reasonable opportunity to explain incriminating facts and circumstances in the case, to explain or that what led him to do this action, or what all the facts and circumstances of the case were at his position when he was at that particular instance when the crime was committed. So उसको भी एक चांस दिया जाता है अपनी बात बोलने के लिए. Defense evidence. If after taking evidence for prosecution, examining accused and hearing prosecution and defense, judge considers that there is no evidence that accused has committed the offense, judge is required to record the order of acquittal. Now if after taking all the witnesses and all the evidence, all the documents, records, सब कुछ देखने के बाद prosecution, defense, prosecution is, मैंने आपको बताया, defense is जो lawyer accused की तरफ से लड़ता है, अपने defense में बोलता है ना, तो वो है defense lawyer. तो prosecution defense lawyers को सुनने के बाद, उनकी दलीलें सुनने के बाद, if judge sees that there is no prima facie or no solid evidence that accused has committed the crime, then obviously it is benefit of doubt which is granted to the accused and he is set free. However, when accused is not acquitted for absence of evidence, a defense must be entered and evidence adduced in its support. For this purpose, defense may examine witnesses including the accused. Witnesses produced by defense are cross-examined by prosecution. Witnesses presented by the prosecution are cross-examined by defense, and vice versa is also true. You may have seen those court cases in films or TV serials. जो एक का lawyer होता है वो दूसरे के witnesses को questions पूछ सकता है, उसको उलझा सकता है. So that all happens in reality also. Absence of evidence अगर नहीं है तो और evidence इकट्ठे किए जाते हैं in its support, and if absence of evidence is not there, then the defense, that is the lawyer from the side of the accused, he presents the evidence in its support, that see, these are the evidence that why I am saying my client has not committed this crime. So that all happens, and he can examine witnesses including the accused. वो जज के सामने ही उससे क्वेश्चन पूछ सकते हैं, and also he can cross-examine the witnesses which are presented by the prosecution, and prosecution witnesses को defense cross-examine कर सकता है. Most accused persons do not lead defense evidence in India. One of the major reasons for this is that the burden is cast on prosecution to prove the offense, and degree of proof required in a criminal trial is proof bound reasonable doubt. As I said, solid proof होना चाहिए. अगर solid proof नहीं है तो benefit of doubt मिलता है, मतलब कि क्योंकि हमारे पास sufficient proof नहीं है उसके खिलाफ तो हम उसको छोड़ देते हैं. एक सॉलिड प्रूफ नहीं है कि उसी ने क्राइम कमिट किया है. एविडेंस तो बहुत सारे हैं बट कोई भी ऐसा पुख्ता नहीं है जो पॉइंट कर रहा है कि हाँ इसी बंदे ने किया. सो ही गेट्स अ बेनिफिट ऑफ डाउट एंड वो एक्विट हो जाता है, उसको फ्री कर देते हैं. तो मोस्ट अक्यूज्ड पर्सन्स प्रोसिक्यूशन पे इतना बर्डन होता है दैट यू हैव टू प्रूव द ऑफेंस समहाउ, and it has to be reasonable doubt, beyond reasonable doubt. इतना सा भी, मतलब बहुत थोड़ा सा भी डाउट नहीं रहना चाहिए, आपका इतना अच्छा सॉलिड प्रूफ होना चाहिए अक्यूज्ड के खिलाफ. ये बर्डन होता है प्रोसिक्यूशन पर. This is quite a high standard that prosecution must meet. It is not enough for prosecution to assert that accused has committed the offense. Judge must be convinced beyond reasonable doubt that it was in fact the accused who committed the offense. As I said, बहुत ही solid proof beyond any reasonable doubt होना चाहिए. जज पूरी तरीके से कन्विंस हो जाए प्रोसिक्यूशन की बात से कि हाँ यही बंदा है जिसने ये क्राइम किया है, इसके अलावा और किसी ने नहीं किया है. तो बहुत सॉलिड प्रूफ होना चाहिए. सबसे पहले तो यू एज अ लॉयर मस्ट हैव द ability to convince the judge in anyhow that yeah, I am saying correct and this person has committed the crime. So prosecution has a huge burden on his shoulders that he has to prove beyond any reasonable doubt, with solid proof in hand, that this person, this accused, has only committed the crime and no other can be the accused. So judge must be convinced with his things. Final arguments. This is the final stage. Provisions of CRPC provide that when examination of witnesses for the defense is complete, prosecutor shall sum up the prosecution case and accused is entitled to reply. These are the final arguments. So what happens in the final stage of trial? According to CRPC, after the examination of witnesses, cross-examination or self-examination, when it is complete, prosecutor shall sum up the case and then it is given a chance for the accused to reply to the claims or to the charges which are set against him. And one more thing, एग्जामिनेशन इन चीफ और सेल्फ एग्जामिनेशन का मतलब है कि अगर डिफेंस लॉयर है तो वो उसी विटनेसेस से बात करे जो उसने प्रेजेंट किया है एंड वाइस वर्सा. और क्रॉस एग्जामिनेशन का मतलब है कि अगर डिफेंस लॉयर है तो वो उन विटनेसेस से क्वेश्चन पूछ रहा है जो कि प्रोसिक्यूशन ने प्रेजेंट किया है एंड वाइस वर्सा. ओके, डोंट गेट कंफ्यूज्ड. Judgment are obviously जब सारे arguments हो गए तब now it is the duty of judge to give the verdict. Under CRPC, an accused can be withdrawn from prosecution at any stage of trial with permission of court. If accused is allowed to be withdrawn from prosecution prior to framing charge, this is a discharge, while in cases where such withdrawal is allowed after framing of charge, it is acquittal. At any point of time, accused can be withdrawn from prosecution means उस केस से उसको हटाया जा सकता है. इफ़ इट इज़ बिफोर द फ्रेमिंग ऑफ चार्ज तब हम कहेंगे कि उसको छोड़ दिया, चार्ज शीट ही नहीं बनी तो उसको छोड़ दिया. लेकिन चार्ज शीट बनने के बाद और ट्रायल लेने के बाद अगर ये हुआ तो हम कहेंगे कि वो बाइज्जत बरी